This morning, 8 Iowa businesses sat in court after suing the state over a new law capping consumable hemp products like edibles and beverages containing THC. Our Local 5's Connor O'Neill is joining us from Des Moines after attending the hearing. Connor, what did each side argue today?
Well, Larissa, the state is arguing that the description of a container size isn't vague, and that's because they say that the Department of Health and Human Services has been informing companies if their products are in compliance with the law. Now, those businesses that are suing the state are then in turn arguing that the Department of Health and Human Services has been inconsistent into responding if their products are now legal after that law went into effect on July 1st, and because of that, these companies have been left guessing. In a hearing at the federal courthouse in Des Moines Thursday, 8 Iowa businesses suing the state argued and offered rebuttals for over 3 hours. Plaintiffs allege the state law capping consumable hemp products containing THC, a chemical compound that makes someone feel a high effect, at 4 milligrams per serving and 10 milligrams per container, is vague, inconsistent, and bans most of their products.
Our customers are confused, we're confused, there's no guidance. There's so much miseducation about our industry as a whole that everyone's just kind of frozen right now.
Plaintiffs said what defines a container size is also vague, but the state argued there has been guidance with its compliance because it created a portal for companies to submit its products following state law. It also argued against the businesses saying this case isn't of criminal nature, but instead more of just a safety and health issue. However, since the law went into effect on July 1st, business owners selling edibles and beverages containing THC have worried about their products' legality.
This is our livelihoods. Like this is everything to us. It's our businesses, our families, right? Our customers. It impacts everybody. So the longer it takes, the more it impacts us.
Climbing Kites, one of the plaintiffs in the cases, asked the court to enjoin the law until the federal government can specify what they call our clearer regulation limits. But the state asked the court if it were to grant an injunction to do so only to the 4 milligram serving size. The status, however, of both cases remain without a decision as of Thursday afternoon. Now, Larissa, before a decision is made on those cases, as you just heard by that district court, further documentation will have to be submitted before the court before it settles the fate of those injunction requests. Larissa?